Hey, what is up, everybody? This is Digital Drive, and I'm your host, Russell. This is the show we talk about technology and, well, whatever else. I don't even know. We're going to talk about whatever. 6 minutes after the hour right now, too, by the way. 82 degrees. It spiked. Temperature spiked. I've been here since about 6:30 because traffic was bad for some reason. Those of you guys who were out there on the roads this morning, traffic was bad. What was up with that? Is that your fault? Because I'm mad at you if it was. But traffic was terrible this morning on 75 going up to 153. Thank goodness the dam is open though, because the Chickamauga Dam was closed for so long, and it was just how long was it? It wasn't even 2-3 days, and it was just a nightmare. I thought there was going to be anarchy, people rioting in the streets, but man, I'm glad they fixed that. Those of you listening in South Pittsburgh, of course, you didn't have to deal with that headache because South Pittsburgh is not Chattanooga and they don't have the Chickamauga Dam to close, so you guys have it good with the traffic being okay. I envy you guys over there in South Pittsburgh on 910. Hey, you guys in 1190 Dunlap, what's up, everybody? This is Digital Drive. I just came in from outside and my eyes have not adjusted yet, so everything looks way too dim. Don't you hate that? I'm a tech guy. I'm not by any means an outside guy. If I step outside for more than about 7 minutes, I melt. So it's just terrible for me. But we got this cool story here from Ars Technica that I've been reading up on, and this is a subject that's very sensitive to me as a privacy advocate, you might say. That would be an accurate term. Cops must have a warrant to search cell phones, rules the Supreme Court. Well, thanks, guys. I thought that would just be a given, seeing as the whole, the Fourth Amendment thing, searches and seizures and all that stuff. Well, no, they've only just now finally ruled that, and it's a unanimous vote too. Supreme Court on Wednesday ruled unanimously that the authorities generally may not search the mobile phones of those they arrest unless they have a court warrant. To further complicate the scope of privacy interests at stake, the data user views on, what kind of wording is that? Data user views on many modern cell phones may not be, in fact, stored on the device itself, says Chief Justice John Roberts. Oh, John Roberts, that's what he wrote. That explains why it's written like a 5-year-old wrote it. John Roberts does not know what he's doing half the time. I don't know what is up with that guy. He's like, oh, the Supreme Court is going to vote on NSA stuff. Well, I'm going to be crazy and vote against it. I think the NSA is actually good. I was dropped on my head. I can't stand that guy. Treating a cell phone as a container whose contents may be searched incident to an arrest is a bit strained as an initial matter. What does that even mean? Well, I will translate for you because, fortunately, I speak idiot. So what it means is, fortunately, I speak Lee. What it means is a cell phone is treated as a container that has your property in it, so it's like a cell phone is now basically a backpack in the eyes of the police. They can't search it without a warrant. A cell phone is an extension of your house or your car. They can't search that without a warrant. So this is good news. I know there's some statist out there who's like, hey, the police should be able to look through people's photos if they think that they might possibly, maybe at some point in the future, Minority Report sort of situation, they might be a criminal at some point, I don't know. Then they can search your phone. No, it doesn't work that way. It doesn't. And I hate that too, because there's a lot of people out there who have this crazy idea that searching people's cell phones based on suspicion is totally okay. Well, no, it's not. And now they have to have a warrant. Thank you, Supreme Court. The Supreme Court did something good. If I had a crowd in here, I'd have them clapping for me. The Supreme Court did something good. Congratulations, Supreme Court. This never happens. So there must have been some malfunction in their programming because now they are actually doing good things. Except not, but we're going to get to that in a second. What do you think about this ruling, though? Do you think that they should have to have a warrant to search through people's cell phones? You can tweet at us. Hot News Talk Radio on Twitter. That's Hot News Talk Radio on Twitter. If you want to tweet at us and tell us what you think about this whole idea of police searching through your cell phones. Do you like that, or do you think that's kind of not a good thing? So do you side with the Supreme Court on this decision, or do you think that was a horrible, horrible idea? For once, I actually side with the Supreme Court. It's bizarre. It is wacko, I know. But I do. So Hot News Talk Radio on Twitter, and you can call in, 423-800-8949. You can call in for any reason at all. You have a tech question, you want to yell at me, you want to say that I'm some crazy right-wing libertarian. I don't care. 423-800-8949. I've lost my place completely because my phone decided to freak out. Here we go. It's perhaps the biggest digital age privacy decision in the High Court that the High Court has rendered following its 2012 ruling that authorities usually need warrants to affix GPS trackers to a suspect's vehicle. And before that, by the way, people were finding FBI GPS trackers on their cars. One guy actually took one off of his car and kept it in his house for a while, and allegedly, there's no proof of this, but allegedly the FBI came and asked for it back because that's federal property, this GPS tracker. I mean, that's some Men in Black stuff going on there. That's freaky. President Barack Obama's administration and prosecutors from states across the country had lobbied the High Court in briefs to allow police officers to be able to search arrestees' gadgets, not just mobile phones, without a warrant. Truly, this administration is a champion of privacy. The justices declined to do so, saying privacy comes at a cost. Privacy comes at a cost. Leave a call. Caller, you're on the air. What's up?
It's interesting about being able to just grab someone's phone and look through it without a warrant, because I talked to a federal marshal who thought that that was okay.
Really?
I mean, yeah, the excuse he gave was, well, what if your 7-year-old girl was kidnapped and potentially being raped, and we had a suspect in custody? The time is of the essence. Don't you believe we should have the right to do that? And I went, no. I would go through it, but you can't use the evidence on that phone against them. That's all that is. Obviously, if there was that kind of issue and there was a hot pursuit, yeah, you're going to look through the phone as a cop, and you're going to gather the evidence to save the kid at that time, but you rescue the kid and then deal with the prosecution later. You just won't be able to use that as evidence. But certainly there's got to be some other evidence you can use, so don't use that as an excuse. You know, the Supreme Court said in Miranda versus Arizona, that's the case where the police, according to the Supreme Court, must advise you of your right to remain silent.
Right, that's where Miranda rights come from.
But one of the things the court said was that the state is so powerful, it has so many resources, that if it has to stoop to beating a confession out of you, we're going to throw it out. One individual against the state, the individual has no chance. So why in the world would you have to beat the confession out of them if you can't gather the evidence based on all the power and resources of the state? In that case, the Supreme Court was correct.
Yeah, it comes to a point where it seems like it simply was not meant to be. You know, you gotta beat the tar out of the guy to get info out of him. It seems like you know, maybe you don't have much of a case if you don't have evidence.
Now, I can tell you this: if I knew this guy was a convicted felon and I was a cop and I suspected he kidnapped someone, would I bring him to the back room and beat him with a rubber hose? Sure would.
Oh, sure.
Where's the kid? I'm not telling you. And when he told me where the kid was, we find the kid, find enough other evidence to find him guilty.
And you might even be charged with police brutality, but you know what? It'd probably be worth it because he saved a kid.
Well, the point is, you couldn't use the beaten confession as evidence against them, but you know, if you still use the evidence, then sure you can. So anyone that claims that we need to violate someone's rights for the greater good needs to leave the country.
They really do.
Okay, they keep telling libertarians and so-called conservatives, we need to leave if we don't like it. Now, if you don't like the Constitution and the rule of law, the concept of the founders of our Christian country, you need to leave, which means all of the Democrats, most of the Republicans, should get on a ship, a boat, and a plane, and leave. Go. All right, thanks.
Yeah, thanks, man. Excellent call there from that caller. And of course, you can call in too, 423-800-8949. That's an interesting concept, though, that Republican, there would be a politician boat lift. Maybe we could send all of them to Cuba, you know? I mean, hey, it would be payback for what they did in the 80s or 70s, whatever it was, before my time. That's a good idea, congressional boat lift. You know, this raises an interesting idea. But he's right, he's absolutely right. The caller is right in that you can't just suspend somebody's rights because of suspicion. It doesn't work that way. And furthermore, it's wrong. You know, this whole greater good social contract thing, you see this a lot. You see this a whole heck of a lot, this whole social contract deal where they say, well, because you live here, you've, without your knowledge, signed a social contract. No, it doesn't work that way. It really doesn't. A social contract, you have to have given consent to sign a contract. That's why minors can't sign them. They aren't of a proper state of mind to do so. That's why Social Security doesn't really work. But this whole cell phone deal, man, it's personal property, and they do need a warrant to search through your personal property. It's plain and simple, really. I don't know why this is such a difficult concept. I'll tell you why. I'll tell you why it's a difficult concept. Because we have old, outdated people in the Supreme Court who don't understand how tech works. And that's fine if you don't understand how tech works. But if you don't and you're not hip with the times, you really shouldn't be in the Supreme Court if you don't understand how present society operates. You can't make relevant decisions based on that. You don't know how a cell phone works, then who are you to make decisions based on how cell phones work? Because you don't know how. It's ridiculous. But the Supreme Court tends to be kind of ridiculous anyway in the present day and age. They probably always have been, you know. But this is a good decision that they've made, finally. A good decision the Supreme Court has made. You cannot search somebody's cell phone unless you have a warrant, legally. The evidence, if you search somebody's cell phone without a warrant, then that evidence cannot be used against them in a trial. I think this is an excellent decision. And to disagree, gotta say, if you disagree with that, that sounds kind of statist to me, you know? And have you noticed that though? The parties have sort of, I don't want to get too, overly political, but the parties have, there's not a whole lot of difference between them, really. It's bizarre. And it says here in the Ars Technica article that President Barack Obama's administration and prosecutors from states across the country had lobbied the High Court in briefs to allow police officers to be able to search arrestees' gadgets. Not just mobile phones, by the way. This could be pagers, personal assistants, PDAs, if you still carry one, who knows, without a warrant. The justices declined to do so, saying privacy comes at a cost. Modern cell phones as a category implicate privacy concerns far beyond those implicated by the search of a cigarette pack, a wallet, or a purse. A conclusion that inspecting the contents of an arrestee's pockets works no substantial additional intrusion on privacy beyond the arrest itself may make sense as applied to physical items, but any extension of that reasoning to digital data has to rest on its own bottom, the court ruled. The court added, prior to the digital age, people did not typically carry a cache of sensitive personal information with them as they went about their day. Now it is the person who is not carrying a cell phone with all that it contains who is the exception. And that's absolutely correct. The court actually, for some reason, made a correct decision. Because your cell phone probably has your bank info, all of your contacts, by the way, most likely. You're probably still logged into your Facebook, your Twitter, so everything you've ever said online and everything that you've done financially, according to your bank accounts, is there. It's all there. And anyone you associate with is right there. Now, granted, you have freedom of association. You can hang out with whoever you want. But cops are kind of hardened guys, especially around here where we have this gang problem. So they say, oh, you have a gang member in your contacts. Well then, he says as he's searching through your phone, we're going to grill you about that too. And they simply can't do that without a warrant anymore. Thank goodness. Or if they do, it won't be admissible in court. And honestly, here's my little tip to you. Don't say anything. If you get arrested, if you get detained, keep your mouth shut. Do not say anything to the police, ever, for any reason. Unless you can offer information against somebody who is oppressing you in some manner, somebody who you want to give evidence against. Unless you're in that situation, do not say anything, because that's your Fifth Amendment right. You cannot incriminate yourself, or rather, they cannot force you to incriminate yourself legally, but they do it all the time. So, do not allow that to happen. Don't say anything. If you get detained, say, am I free to go? And if they say no, then keep your mouth shut. After that, just don't say anything. Because I can guarantee you, they're taking mental notes on everything you're saying past that point, or even before then. Because that's what they're trained to do. As policemen, that's what they're trained to do. They're trained to be detectives, in a sense. Even if they're not detectives in rank, then they are trained to act as such, mentally. So you have to keep that in mind. Don't give them anything. Don't say anything. They will use their training against you if they suspect that you've done something wrong, or even if they don't, they just want to get on your nerves. So don't say anything. And of course, be courteous and respectful to them, but don't give them any information that could incriminate you. Maybe you're carrying some pot in your pocket, right? I don't know. I don't care if you do, but it's still kind of illegal right now. So don't give them any information. They say, hey, is this yours? You don't have to say anything. Don't say, well, actually, it's my friend's who, no, don't say that, because that just makes you look like an idiot. Don't say anything. How did that get there? My friend must have put it. No, don't even do that. Just don't say anything at all. That's my tip to you. And of course, I'm not a lawyer, I'm not some legal expert, but that's my little piece of advice to you. Don't say anything. In fact, that tends to be a pretty good practice just in general. Don't say anything. Keep your mouth shut, kid. Well, the court justices said that waiting for a judge to issue a warrant is not needed in every case if there are exigent or emergency circumstances. So this falls under what the caller was saying in this case. In light of the availability of the exigent circumstances exception, there is no reason to believe that law enforcement officers will not be able to address some of the more extreme hypotheticals that have been suggested. A suspect texting an accomplice who, it is feared, is preparing to detonate a bomb, or a child abductor who may have information about the child's location on his cell phone. The defendants here recognize, indeed, they stress that such fact-specific threats may justify a warrantless search of cell phone data. So, there actually is, the court justices have determined, justification for doing that. So that's covered. Now, they have to absolutely, beyond a shadow of a doubt, be able to prove to the court later that they believed that this was the case. So don't be confused. They can't just run around and say, oh, you may detonate a bomb, let me look through your phone. They have to absolutely believe that and prove to the court that they believe that at the time. So they know better than to just go up and say, hey, you might detonate a bomb, give me your phone. You know, they're not going to do that to you, most likely. But I think this is a good exception, I have to say. As much as I am a privacy advocate, I have to say there is a case where you could kill a lot of people and there'd be nothing they could do about it unless they looked through your phone. So, extenuating circumstances, I'll grant you that one. But again, the information can be used against you if they believed that that was the case and it turns out that it was the case. So, that's, I can see that one. Even as a privacy advocate, I'll grant you that. That one's okay. So, privacy, hey, privacy wins the day in this case. It's about dang time. But the Supreme Court has done something very dumb immediately afterward, or maybe before. Anyway, pretty much at the same time, the Supreme Court did something really stupid. The Supreme Court puts Arrow out of business. Yeah, TV over Internet startup's tiny antenna scheme apparently violates copyright law. Arrow, according to Ars Technica, a TV over Internet startup whose legal battles have been closely watched, has been ruled illegal by the Supreme Court today. If the company survives at all, its business model will have to change drastically, and it will have to pay fees to the television companies it has been fighting in court for more than 2 years. In a 6-3 opinion, thanks guys, written by Justice Stephen Breyer, Arrow was found to violate copyright law. According to the opinion, the company is the equivalent of a cable company, which must pay licensing fees when broadcasting over-the-air content. Viewed in terms of Congress regulatory objectives, these behind-the-scenes technological differences do not distinguish Arrow's system from the cable systems, which do perform publicly, reads the opinion. And that is kind of a sticky situation, but I don't see why they're viewing them as any different from Netflix in that sense. I guess because you can view live TV and all that sort of thing, still, that one's kind of sticky, I think. It's internet, it's not over broadband, or it is over broadband, I should say, but it's not over a cable system in the same way that cable internet is, or satellite internet. So the fact that they have to get licensing fees, I think it's just that cable company lobbying, trying to hurt the little guy, because cable companies, for TV, that's totally outdated. You know, we have Netflix, Hulu Plus, what else do we have? HBO Go, AMC streams their stuff on their website. We don't need all these cable companies anymore. In fact, most people my age, college-age kids, don't even bother signing up for cable TV. We just want the internet and the phone, maybe. Probably not even the phone. We just want the internet stuff. I mean, court justices are kind of stupid anyway, honestly, and the whole situation is kind of screwy. But, well, that's their opinion, so it is now law. Thanks, guys. We have determined that it is now okay to charge people tons of money to watch TV, so thanks. Or rather, to charge companies tons of money to let you watch TV. It's like, we just hate competition here in the States, according to court justices. We just hate competition, unless it's some other case in which they like it. I don't know, they're so inconsistent, it makes no sense. Supreme Court. I just don't get it. We're going to talk more about the Supreme Court, though, next in just a few seconds, but first, we're going to bring you the world news right here, Hot News Talk Radio. And you can call in 423-800-8949. Hold on. Fall in. Ugh.
NASCAR, Laura Ingram, Dennis Miller, David Toulis, Generation Z, Coast to Coast AM, and CBS Radio News. Chattanooga's news, talk, and sports leader. Fox News Talk 1240.
The right to keep and bear arms. It's your birthright. Be a stakeholder in the Second Amendment with an AR or an AK in self and home defense, in personal safety, firearms plus